Thank you for joining us for another episode of The Office, where our door is always open. Today we'll be talking about discipline management. What is discipline? What is the process that we follow? When is it applicable? So we'll be talking about this and much more. So don't go anywhere. We'll be right back after the break.
The Office is brought to you by Renwick & Company Limited, multi-graphics powered by Expert Group and the Goddard Catering Group.
Welcome back. Thank you for staying with us. Today we'll be talking about discipline because it's an area that is still a challenge for many organizations. And if not handled properly, can result in serious payouts for the organizations. It can also result in damaged relationships with their unions, for those who are operating in a unionized environment. It can also impact negatively on the employee relationship. And so we felt it important to talk about this topic and try to identify and highlight the important aspects that we need to keep in mind when dealing with discipline. So to help me identify some of the key areas that are related to discipline management, I am joined by Mr. Joseph Alexander, who is the Executive Director of the St. Lucia Employers Federation. Mr. Alexander has over 30 years experience in management, having served as a director on the ECFH board and also chairperson of the Bank of St. Lucia. He has been with the Employers Federation for 9 years now as the Executive Director, and he is very familiar with the labor code, so we have quite a bit to learn from him in that respect. Thank you so much, Mr. Alexander, for accepting our invitation to join me here at the office.
And thank you very much for inviting me.
You're welcome. So, Mr. Alexander, I think one of the first things that we need to clarify when we talk about discipline management is, first of all, what is discipline? What is discipline and when is it effective, or when do we put it into the discipline management part? When do we put it into effect?
Okay. For a system of business to run well, it must be disciplined, it must be organized. Mm-hmm. And any time that you do not have a proper organization and there's indiscipline, all hell breaks loose. So discipline must be adhered to, and with the advent of the labor code of St. Lucia in 2012, there is a process for disciplining. Mm-hmm. And this is what I would like to share with your audience today.
Yes, a very good place to start. So understanding what that process is. So in St. Lucia, we follow the progressive discipline process, and so you could go ahead and share with our audience the different steps related to that.
Yeah. The progressive discipline is, as the term says, it's progressive. So, for example, you may begin with a verbal warning. From a verbal warning, and let us take, for example, punctuality. Mm-hmm. So the very first offense, the first time somebody comes late, you won't go about issuing a written warning. You would begin with a verbal warning. So it progresses along the line of verbal warning, then a first warning, then a second warning, then a third, which is called a final warning. And if the infraction is committed another time, then you move towards what is called a disciplinary hearing. And from the disciplinary hearing, you may choose to terminate. The law allows you to terminate employment.
Mm-hmm. Okay, so obviously there are specific things that we need to keep in mind when we talk about these different steps in the discipline process. So for the verbal warning, we always encourage persons, even if it is a verbal warning, you should still keep a record of it to some extent. Do you agree?
That's correct. That's correct. And so when you give the first written warning, you now reference the verbal warning in that first warning.
Yeah, because within the discipline process, it is absolutely critical that we keep record. Because that's what is going to help to define the outcome of whatever that infraction or the behavior that we're trying to discipline the employee for.
Yes, in fact, the labor code as it is, it only understands written warnings.
Right.
So even if you were to issue a verbal warning, and the code would only allow the tribunal to look at written warnings.
Right.
So the very first verbal warning, it's not, in a way, it's not recorded. It's 3 written warnings, and then you move on to the natural justice hearing.
Right. Okay, so can you share with us what are the key things that we need to keep in mind in preparing the written warnings?
Okay. So a warning should consist of about 3 things. The first one is you must identify what the warning is for. So, for example, in the code you would have something called misconduct, which is a minor offense. And lateness would be one of those.
Right.
Right? So the warning would say, first warning, misconduct. Then you would specify what the misconduct is. In
Right.
this case, we would say lateness. Right? Then you need to reference the warning against something like in your employee handbook, you would have a policy on lateness.
Right.
So you would go on to say in the warning that it is in contravention of the company's policy on lateness.
Right.
Right? And finally, you end the warning by saying what would happen in the event that another infraction occurs.
Right. Okay. One of the areas that I always focus on when I talk to people about preparing written warnings is, in addition to all of what you said, to avoid using I and making it about exactly that, the policy that has been breached, the issue that is at hand, and not so much that relationship. Because you see, when persons use I, the employee can say, well, you know, this manager has something against me, especially if there's a disagreement, personality clash, or anything like that. So I always encourage them, you know, outside of just keeping to the facts and all of that, the tone of the letter should be as a representative of the company and not you personally, the manager. Yeah?
So I'm in total agreement.
Yeah. All right. We have to take a break now, but when we come back, we'll continue the conversation around the discipline process. Thank you so much for staying with us. Before the break, we were talking about written warnings. So, Mr. Alexander, can you share with us some examples of situations where written warnings would be warranted?
Okay. There are 2. There's misconduct, which is the minor offenses,
Right.
and there is serious misconduct, which are the graver ones. Whenever there is any misconduct at all, written warnings will be issued.
Right.
In the instance of misconduct, such as lateness, or any minor infraction like somebody smoking in a non-smoking area, nothing major, you need to issue 3 warnings.
Right.
And
written
then
warnings.
3 written warnings, and then a disciplinary hearing.
Right.
Whereas for serious misconduct, which is more serious, and that would be somebody misbehaving at work,
Fighting,
threatening, fighting,
theft,
etc.
yes.
These you only need to issue 2 warnings,
Okay.
right? So you could be, in fact, depending on the gravity of it, you may issue only 1,
Right.
right? So for example...
Or it could be summary.
Yes,
be
or it could be,
immediate,
right, immediate, so like theft. You would not issue any warnings for theft.
Right.
You would go straight to a disciplinary hearing and you could terminate.
Right.
Right? But for example, like neglect of duties or disobeying a lawful order given by the management, these would entail 1 warning and then a disciplinary hearing.
Right.
So I want to make the difference. I want to draw your attention to the difference between misconduct and serious misconduct.
Yeah. So where does the suspension come into effect within the progressive discipline process?
Okay, there are two types of suspensions. The first suspension is a suspension with pay.
Right.
This comes about if somebody has carried out a serious misconduct and you need time to investigate the matter. So for example, like fraud, if there is an issue of fraud, then you would suspend that person while you investigate the matter.
Right.
And this is paid
Yes.
suspension. The other suspension.
But there's is there a ceiling, a time frame?
Oh yes, there is a, thank you, there's a ceiling of 4 weeks. So you can only suspend for up to 4 weeks.
Right, so the employers need to ensure that
Sure.
they do everything within their power to stick within that time.
Within the 4
Yes.
weeks. Once the 4 weeks are up, you've got to get the person back into work. Otherwise, you're breaking the law.
Okay.
The other one is after a disciplinary hearing, the law gives you the option to suspend the employee. If you do not want to terminate, it gives you the option to suspend without pay. And that's the only time you can suspend without pay for up to 4 weeks
Right.
as well,
Yes. So that's in lieu of dismissal.
in lieu of dismissal.
So the practice that is currently being followed where persons are being suspended for minor infractions, you're saying that that is incorrect?
Yeah, in fact, it's illegal now. It used to be under the old labor laws. You could have.
Yeah.
But
I think
with
you
the-
need to repeat that,
yeah.
Mr. Alexander, because I don't know, I don't think that a lot of companies realize that.
Yeah.
Because it's still being done a lot. Persons are being suspended in the middle of the process. So sometimes even before the second warning letter,
Wow.
suspensions are being effected.
Yeah, well, that's totally contrary to the Labor Act.
Right.
And in fact, the code is now called the Labor Act 2006. But we can use the code because that's what most of us are accustomed to
Yes.
using. The suspension without pay can only be done after a disciplinary hearing and you have found that the employee is guilty.
Right.
In lieu of dismissal, you can choose to suspend the person without pay
Right.
for a period of up to 4 weeks.
And obviously, the period that you choose must match the offense.
That's correct,
Right.
yes,
So
because
the gravity
the
of-
gravity of the
yes.
offense will decide. But again, it's up to the employer to
right.
decide how much time they would the gravity of it.
Yeah,
So
I
the-
guess the circumstances surrounding the incident as well
Yes.
would play a big role in helping
Very
to
big role.
define how long that suspension period should be.
Yeah, that's correct.
Okay, so Mr. Alexander, what about discipline during the probationary period?
Okay, the probationary period is the only time that the employer can terminate an employee without a disciplinary hearing or for no reason at all. The code specifies that the probationary period is 12 weeks. And the probationary period is a time at which you could come up with your assessment of the employee.
Right.
Right? And normally, the probationary period is 12 weeks, but if, for example, the employee is not quite there at the end of the 12 weeks, the code allows you to extend the probationary period
For further.
for another 12 weeks.
right.
So in other words, custom and practice have never seen a probationary period of longer than 6 months.
Right.
Right? But the most important thing about the probationary period is that's the only time that you can terminate without giving a reason. You don't have to pay notice. You don't have to pay vacation. There is nothing
And you don't
to pay.
necessarily have to give any warnings.
No
during that
warnings, no
period.
reason.
Yeah.
Right?
Okay.
So the probationary period is a very important period.
Yeah.
And that's the only advantage to the employer I can see for the time being.
Okay. All right. Well, thank you very much. This has been an interesting discussion. We will be right back after the break. Don't go anywhere. Thank you so much for staying with us. I've been having a very interesting conversation with Mr. Joseph Alexander, Executive Director of the St. Lucia Employers Federation, about discipline and discipline management. So, Mr. Alexander, what is the natural justice hearing in its, I guess, its true sense? Why? Why are we now required to conduct a natural justice hearing? Because we didn't have that requirement before.
Yeah. Right. What was found was that under the old legislation, an employer could terminate your services and just pay you notice.
Right.
The employer was not bound to provide you with any reason.
Yeah.
Right? With the advent of the code, you can only terminate somebody, an employee, for cause. They must have done something wrong to be terminated.
Right.
Right. And the concept of natural justice is a concept in law, and it was incorporated in the code to ensure that there is fairness in termination of employment.
Right. So there are certain safeguards.
That's right. There are certain safeguards, and basically the safeguards are: one, the person must be given a fair hearing. And by fair hearing, it means that if you, the employer, were involved in investigating a matter, you cannot be the chairperson of that disciplinary hearing.
Right.
In other words, you cannot be the judge, jury, and executioner.
Right. Yeah.
The second aspect of it is the person must be given an opportunity to be heard, so the person can lay their case and controvert whatever arguments that you've brought, whatever evidence that you've brought. The third one is that the person must be given an opportunity to be represented. And in fact, the code goes to the extent and says legal representation.
Right.
But does not necessarily mean that the person must bring a lawyer. What you have to do is give the person an option,
Opportunity, yes.
right? If they so choose to bring a lawyer to
Right.
represent them.
But also if they so choose to bring their aunt, their brother, cousin, whoever they choose to bring with them, we must allow them that opportunity.
That's correct. They can choose whoever they want to represent them, to the point of if they choose a lawyer, you have no option but to allow it.
Yeah.
And the final one is you must lay out all the particulars of the offense, so the person doesn't come in blindsided.
Right.
So the person know what they are coming to defend themselves against. So these are basically the four tenets of the natural justice, and that is, if you're going to do a natural justice hearing, you must ensure that those four tenets are sustained, are applied.
Yeah. This is an area of concern for a lot of employers because it's a time-consuming process. And I've heard employers say, you know, that's a waste of my time. Why should I have to do that? What do you think of the effectiveness or the need for us to still have a natural justice hearing, even when it is very evident that the person is in fact guilty? And in some cases, the person may have even acknowledged or accepted or, you know, said very clearly that, yes, I did this and yes, I accept full responsibility. But the law still requires us to have this natural justice hearing. What do you think about that?
You see, the natural justice hearing is, in a way, to as well find out that whether the person is guilty or not. But it also gives the person an opportunity to mitigate. So something may look black and white to you, but there may be mitigating circumstances.
Right.
And that was one of the key reasons behind the natural justice. is also to give the person an opportunity to explain the mitigating circumstances, if any, and also to seek to see whether you could be compassionate.
Right. The
Right?
employer, yeah.
Yeah, the employer can be compassionate as well.
Under the circumstances.
That's correct. That's correct.
All right. So in the event that coming out of the disciplinary hearing, the natural justice hearing, a decision is taken by the employer to terminate this employee, what are the key things that we need to keep in mind as employers once we get to that point?
Okay, one of the key things we must always be aware of is that the employee may choose to appeal.
Right.
Right. The appeal process in most instances is through the Labor Department. So the employee may go to the Labor Department and say, listen, I was unfairly dismissed.
Right.
And the employee and the Labor Department may decide to review the matter.
Mm-hmm.
Right? If the Labor Department will now set up a meeting of the employer and the employee, and if the employee needs to bring a representative, they could,
Right.
and the Labor Department will rehash the matter.
Mm-hmm.
It's important, therefore, that you record, right? And in fact, I would strongly recommend that you do a voice recording
Mm-hmm.
of the whole disciplinary hearing.
Okay.
I would
Okay.
strongly recommend it in the event that you need to refer
Mm-hmm.
to whatever transpired.
Okay. So in addition to the written recording, you're suggesting that we do the voice recording? as
Yes, yes.
Okay.
The written recording is, I would always recommend that you do a report. Whoever chairs the hearing, do a report
Yes.
on
Of
the-
what transpired.
of what
Yes.
transpired and how you came to your
Conclusion, right.
right?
Okay.
Now, why I'm suggesting that you also have a voice recording is, suppose the employee were to say this is not what transpired.
Right. So you can
right?
actually go back
So
to
you
the
can
actual-
go back and say, listen, this is, do you hear what was said there?
Yeah, yeah.
Right?
Well, you know, Mr. Alexander, this has been very interesting, but we are completely out of time. So I want to thank you so much for being our guest here, and I look forward to having a continuation of this discussion in our next episode. Okay, so thank you so much. And until next time, follow us on social media. Contact us at 458-4001 or info@hrwiseinc.com. We'll be more than happy to answer any questions that you may have or to take your suggestions. So until next time.